first question from Salah. It's a huge one and we'll try to answer many, so we need a short answer to a big problem. How do you suggest to control technical giants who collect and sell up our personal data?
Yeah, and that's a that's a big question, and it's one I think that it probably doesn't find its answer in a single area of law. I think privacy law has a role to play here. Competition law has a role to play. There may be other human rights law may have a role to play, but the challenge is to find is to find a way to deal with the fact that we've created a context in which there is this rampant and almost unlimited collection of personal data in incredibly questionable and dubious circumstances. And so there certainly is some role for data protection law to play in that context, but it's got to be a different kind of data protection law than that which we know right now. Again, not only is there the problem of this consent-based stuff, which makes no sense in the context of take it or leave it services that people need or want to have access to, and the inability to understand the privacy policies and so on. But there's also the fact that the laws have no teeth. Enforcement is a challenge. And I think that, frankly, I alluded to the corporate capture of government earlier too. And I think that this is a challenge as well. These corporations wield enormous powers when it comes to lobbying governments. The promise of innovation, the promise of stimulation of the economy, all of these things are carrots that are held out to governments to encourage them to go lightly, to tread lightly with regulation and control. And I think those arguments have often influenced the shape of our privacy laws and particularly the weakness of data protection laws. So I think there are systemic problems in terms of how we govern this kind of behavior. And there are also problems with specific laws. And it's part of the reason why I wanted to focus on privacy as a human right and put that at the core, with data protection just being one way in which that human right is implemented, is because I think too often we just focus on data protection laws and what people can and can't do under data protection laws. And I wanted to put into question the legitimacy of data protection laws if they don't actually protect privacy as a fundamental human right.
Thank you, Therese. The second one is from Tracy Lorio. Are data brokers in Canada regulated beyond PIPEDA? So tell us PIPEDA again. I don't know what that is. So.
Oh, PIPEDA is the Personal Information Protection and Electronic Documents Act. Yeah. That's a good question. My colleagues at CIPIC, David Fewer and Tamir Israel, have done a lot of work digging into data brokers and what data brokers do in Canada and how they act and how they behave. A large part of what data brokers do is governed by PIPEDA, but a lot of it is invisible. And we also have the added problem in Canada that data brokers across the border are not governed by PIPEDA there's a complicated legal answer around that, but there are also ways in which the kind of data that are collected by data brokers flows across the border in ways that have been very difficult to control with data protection laws. So it's not a complete answer to your question. I'm sorry, but that's a really complex context, and one in which I think there have been some significant challenges.
Okay, we have 5 more questions. You're doing well there. So one about how do you balance the interests in the context of public sector needing to use AI to manage public services?
Yeah. Well, the federal government has adopted a a directive on automated decision making and an algorithmic impact assessment tool, which are specifically oriented to try to address some of those issues, some of those balancing issues, some of the ethical issues and privacy issues as well. And so I think I actually find this a very interesting directive and a very interesting tool in terms of kind of providing a framework in which those who are within public service developing or planning to develop and implement AI technologies have to essentially frame an inquiry into the impact that these technologies are likely to have, and to think about how that impact then dictates steps or measures to protect the public. And so I would point to that as being an interesting tool that can be quite useful in that context for covering not just privacy issues, but a broad range of concerns.
So the next question, Therese, is about somebody wanting to hear you more about the collection of biological data.
Uh, Biological or biometric? I mean, and I guess there's a lot of overlap between the two. Um, I mean, biological data is often collected through samples, and so it's protected at a higher level of privacy in that there's usually some invasion of the physical person, and so the individual has to consent to having that needle put in their arm or to the specific collection, although not always. And with technology, that's starting to shift as well. Biometric is more problematic because biometric data can be collected without us realizing that it's being collected, such as through facial scans or other types of scanning. But with biological data, there are often circumstances now where that data is collected without, or can be collected without, crossing that boundary. For example, DNA, we shed DNA in a range of different contexts. And I must say, don't have time to get into it, but the Supreme Court of Canada has some, I think, really problematic jurisprudence around this whole idea of when we have abandoned information about ourselves. And so if you use a tissue to blow your nose and you throw the tissue away, you have abandoned the tissue. And presumably you've also abandoned all of the data it contains, which is your DNA. And that's problematic from a privacy point of view. So I'm not sure if I've really answered that question, other than to say that there is an increasing amount of the collection of that type of data, and by a very broad range of actors. And I think that this will inevitably present some really significant privacy challenges going forward.
So two people asked the same question, so that's good because we've got like 7 to go, and it's about the balance between innovation and personal data. How do you think about achieving this?
Yeah, and that's an interesting question because obviously innovation is important to the economy. Innovation is important. Some of the promised innovation of AI could be tremendously transformative and important in a range of sectors, particularly in healthcare. I think where there really is some interesting innovation taking place that could improve outcomes, reduce costs, save lives, all of these types of things. And so then you're stuck with this issue of how do you find that balance between supporting that innovation, but at the same time protecting privacy. And there are a lot of people who are working really hard on these issues and looking into not only the consent-based data protection frameworks, but in frameworks that will look more broadly at managing data, and we see this much more in the healthcare context, for example, and we have for a number of years now, but managing data for sharing for research or innovation purposes in ways that protect privacy while still allowing that innovation to take place. And so there's been talk about data trusts and data sharing frameworks, new data governance frameworks for AI. And so there's a lot of work that's going into trying to find ways in which information can be pooled and made available for research in ways that still protect the privacy of individuals. And so, I think that's still very much a work in progress.
The next question, Therese, is a historian's question. So what about archiving for the future, very much like the census question. So things that are private now could be not private later. How are you thinking about this?
Uh, Uh, yeah. That's that's a really interesting question. And I mean, it ties into some extent to this idea of the right to be forgotten. One of the things that's interesting about the GDPR, the European General Data Protection Regulation, which will have an impact in Canada. And I think we're going to, I mean, I would, in the next 2 or 3 weeks, I'll say this even though I have trouble believing it, but the rumors are that in the next 2 to 3 weeks, we're going to see a bill to amend the federal private sector data protection laws. We'll see if that happens. But if we do, it will also probably address some of these things that are in the GDPR. And the GDPR has this, what's been described as a right to be forgotten, which is in the GDPR really a right to erasure. But it's a part of a package of rights that start to give individuals considerably more control over their personal information. And I think this is an important step in evolution in data protection law, this enhanced individual control. But the right of erasure is the right to ask that certain information about you be erased and to have it erased. Um, it is a right that's limited by other interests, including the public interest. But it is going to be very interesting to see how we balance this enhanced control of individuals over their personal data and the data that's available about them and the ability to go back and erase that data or limit access to that data, and rights of freedom of expression and rights associated with archiving and other, and freedom of expression is also the right to be able to be informed, how it is going to be balanced with these other rights and interests that people may have to have access to older information about people and events.
Okay, a question about spying. Bailey is asking, Canada is part of the Five Eyes community, and how do you, and private business collecting data, how can you put that together with public regulation of privacy?
That is a really challenging question. So one of the other things to look for in a new privacy bill, if we see one in the next few weeks, is how data transfers for processing abroad will be treated. So I'm coming at the answer to this question a little bit obliquely, because right now data flows fairly freely across borders, and this is a bit of a challenge. And we've seen in the EU with the GDPR and the recent Schrems II decision, the EU framework creates a very robust protection for the data of European residents, and it protects it also when it flows outside of the EU, such that when it flows outside of the EU, the European data controller has to ensure that there is some sort of adequate protection for that data in the other country and that it meets European standards. And what's happened with the Schrems II decision is essentially a finding that the national security apparatus in the United States has such ready access to personal data in the hands of corporations and no effective recourse is available for European residents, such that it's not actually legal to transfer data from the EU to the United States now, under the frameworks that have been created to facilitate that. So it's been a really significant decision, and one that is having all sorts of ripple effects. We haven't got an answer to that question in Canada because we're just Canada, we're not the EU. We have a lot less clout, and we're afraid of what will happen if if data can't flow to the United States, for example. I mean, that's a big part of our economy. And so we're unlikely to take such a bold step. But, again, that's a fundamental issue about government access, and in this case, foreign government access to the personal data of Canadians as it flows across borders. And we don't have an answer to that yet.
So one last question, Therese, about the biases you mentioned. So this one is about an example. How is the statement of Quebec Premier on the non-existence of structural racism might deny the ability to regulate in the ways that you've mentioned?
This is going to be, I think, an ongoing challenge and battle. I have thought, when I've heard some of these statements made in the press, I have wondered if perhaps some people don't understand the difference between systematic racism and systemic racism. Um, maybe that's all it is. I'd like to think that's all it is, that it's a failure to understand the meaning of the two different words, because you could see systematic racism as meaning deliberate, a planned, deliberate, intentional strategy, and that people who are denying systematic racism are saying, no, we don't, that's not what we're doing, we don't have that intention. But systemic racism is something very different. And it doesn't have to be planned or deliberate or intentional. It flows from just deeply rooted and embedded um, norms and biases that have, that affect how we uh, see the world, structure our institutions, carry out business, and that's the challenge, and that is a really big challenge. And I think it does no one any good to deny, it just is unrealistic to deny that there is systemic racism or systemic gender discrimination, because there is. I think it's really uncontrovertible. And so, I think the challenge now is not to prove that it exists. I think we should just accept that it exists. The challenge is to figure out, how do we confront and address it? And that's not going to be an overnight job. That'll be a long process.